Well, hello there, people. It's Doug from Salt Lake. It is March 14th, and we're going to sue child support. You want to sue child support in state court? Let's do that. Okay, so we've got a lot of stuff to go over, but we're not going to read it all today. We're just going to show you what I did and go from there. Okay, so going back, this is May 11th last year. So we went through a lot of stuff. We did a discovery without leave. We did a discovery without leave with the answers, and we sent them this affidavit of default, and we documented that we sent them this. You didn't answer. We sent them this. You didn't answer. We sent them this. Notice of default, non-response. You didn't answer. Okay. So we've documented all of the stuff, and we've basically told them that you are now in default, and all matters not denied were affirmed, and case closure criteria has been met and applies. Okay. And we sent that in. All right, you guys don't have anything over me because everything that you're doing is color of law. Okay, so we sent that in. This is Exhibit 2 that I added to my bill, amended bill in equity. This is my declaration by affidavit in support, which we will go over quickly later. And if you remember correctly, we started our administrative process. We started with a notice of acceptance. And this is really good. I like this language. So it says here, July 8th, I sent you a confirmation letter, and I accepted your presentment for assessed value upon proof of claim. I attached a copy. And again, you'll notice this was registered mail, and this was sent by a notary, not by me. Okay. I sent it to her, and she sent it out. She is a officer of the court and has a little bit more oomph, I guess. What's the word? I guess authority. If you're certified by the state and you're a notary, then you are an officer. You are a franchise. You are a public officer of the court. And so what you say has a little bit more weight when you're in court. But this is good verbiage in here. This is good verbiage. So this letter is my second attempt. Please validate this alleged debt by sending the contract for services I sign with your agency, and I will return a negotiable instrument to you for exchange, in exchange for closure and settlement. Please send proof of claim by certified copy of said contract. Okay. So child support is enforcing some obligation, right, that you have. Well, it can't be an obligation unless there's a contract that you consented to, right? So send confirmation stated obligation for account referenced above will be adjusted and settled via my willingness to discharge this alleged debt with a negotiable instrument to the above address, and send a notice of dishonor from a qualified third party. A copy of my intent to settle will include a bill of exchange, instructions on what to do with that bill of exchange, pre-authorization. Okay, that is a pre-authorization going to the Department of the Treasury, okay, through the back door. Okay, statement of account showing a zero balance. You have 10 days to respond. Okay, I will be enclosing an authorization for you to facilitate the use of my credit. Okay, that's private side, to discharge all court charges and obligations that may apply. The instructions and statement of account will be attached for your convenience. Secretary of Treasury will also be notified by a letter of authorization that I have utilized my credit for this purpose. However, I will not send any documents until I receive a valid contract signed by me, validating and confirming your debt collection activities. Okay, so that's how we started. Okay, notice of acceptance. Now let's go to our notice of default and opportunity to cure. Okay, So this was just really quick. Hey, I sent you this thing. You didn't answer. What's going on? You got 10 days. Okay. Notice of default, opportunity to cure. And then we have our certificate of non-response. So if you guys have watched the other videos, you know about all this. So let's go to the bill in equity. Okay, so we learned some things too from the Fed um, lawsuit. I'm going to put together another one too, because my federal lawsuit, basically, we learned some things. We learned you can't sue a state government in federal court, but if you can prove that they are a corporation, then you might have a chance. But that's another thing. So we're actually working on another document, and if you guys remember, we had an order to show cause, and according to the feds, I'm not in their jurisdiction, and that my pleadings did not grant them jurisdiction. So what I'm going to do is just send a little letter of confirmation to the federal district court and make sure that I thank them for confirming that I am not inside federal jurisdiction. And I'm going to use that later on for Social Security and any other presumptions that these people make. Maybe somewhere down the line, some kind of federal lawsuit comes in or some kind of federal jurisdiction issue comes in. I'm not within the United States as defined in U.S. Code. So here is our amended complaint bill in equity. We went through this before, but I've added a bunch of stuff, and I looked up some things and did a little bit more research. So let's go through it here. So first thing, Douglas Richard Dmoomey, okay, it's always capitalized. Okay, those are the corporations, those are the estates, those are the trusts. Okay, so Douglas Richard Dmoomey obviously can't do anything because it's a trust. So is through Douglas Richard Dmoomey, plaintiff. Okay, ORS, defendant. Amended complaint, bill in equity. There's the case number, the judge. Contracts are resolved in equity courts. Okay, so jurisdiction is hereby granted under Utah Rules of Civil Procedure 17A, Douglas Richard Dmoomey, the real party in interest. Okay, so what's 17A? Okay, so you go to Rule 17, parties, plaintiff, and defendant. 17A is the real party in interest. Okay, that's me, obviously. Every action shall be prosecuted in the name of the real party in interest, an executor, administrator, that would be me, trustee of an express trust, that could possibly be me too, because I have all my trust documents, a party with whom and in whose name a contract has been made for the benefit of another, that would be me, that's the all cap name, or a party authorized by statute may sue in that person's name, blah, 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 blah. Okay, so that's 17A. Douglas Richard Dmoomey, the real party in interest, making a special appearance under Rule 24, intervening in motion as the authorized representative. Okay, so again, what is Rule 24? Okay, Rule 24, intervention. Number 2 right here, when the applicant claims an interest relating to the property or transaction which is the subject of the action. Okay, well, that also sounds like me. Okay, by way of sufficiency of pleadings, an affidavit in support of amended complaint bill in equity is attached and part of this complaint bill, right? So here is our declaration by affidavit in support of amended complaint bill in equity, right? And this is just real simple. This is what I did. I tried to settle this account. They dissed me. I did this with a notary. Okay, this is what happened, and they agreed to the legal notice and demand. They wouldn't do anything that I asked them to do, so they are in default and have created an estoppel. So again, I added some stuff. So let's go over this. The venue of this court is correct. It's Douglas Richard Dmoomey and the Office of Recovery Services. Notice all cap, are operating in equity in the state of Utah, all cap, are not in or on federal territory, which we learned, and the amount in controversy is over 75. Therefore, extinguishes justice court jurisdiction. Okay, justice court is small claims. Authorized representative is a state citizen, an American, domiciled on the land in the Utah Republic, and I, as such status, hereby make this special appearance in my proper person, proceeding sui juris, at law, in common law, assisting. Who am I assisting? I'm assisting this guy right here. Right? Okay? Special appearance, neither conferring nor consenting to any foreign jurisdiction. What's a foreign jurisdiction? That right there is a foreign jurisdiction, state of Utah, right? Except to the judicial power of Utah, and as such, I willfully enforce all my constitutional limitations respectively on the government agencies when dealing with them and reserve all rights, right? So there's the UCC, and there's Utah Code Annotated 70A1-308, which is how they present it. I stand alone before this court by my Creator, with my Creator, as my witness and counsel, and no other. Now, who are the parties? Plaintiff is Douglas Richard Dmoomey, and that is a franchise of, is domiciled in, resides in, and does business in the state of Utah, blah, blah, blah. Defendant is a franchise of, domiciled in, resides in, does business in state of Utah. Okay? So everybody's jurisdiction is correct. Okay, so this is some of the stuff from before. Plaintiff has exhausted administrative remedy. Defendant continues to harass by silence. They agreed to the legal notice and demand. They have established an estoppel. Okay? Res judicata, stare decisis. Civil law only activates upon consent, and without jurisdiction, or as a stolen property from me. Well, not from me, from the plaintiff. Turned private property into public property and violated due process. Because there are no facts and controversies, there is no argument, and the plaintiff does not require a hearing for oral arguments. Defendant's rights to argue have been waived. Why have they been waived? Because it's already been decided and it's already been adjudicated, right? So there's no argument. Defendant, in the ordinary course of business, has a duty to respond and provide proof of claim, right? Defendant's failure to answer and prove its claim is a bill of attainder. So these are some legal claims we stuck in here because we wanted to well plead this. Plaintiff is entitled to relief. Plaintiff's claim is well pleaded and is backed up with an affidavit of default, legal notice and demand, as seen, and you agree to all that stuff. Family law is private law enforced by private corporate regulations called public policy. Family law is private law. Oris is guilty of mixing public and private because family law is private and has no valid lawful claim against the plaintiff. Plaintiff never consented to become or labeled an obligor or a non-custodial parent, right? Because you don't have a contract with me that says, absolutely, I want to be your slave. Violated eminent domain and the takings clause of the Fifth Amendment. If you don't know what that is, you should probably read the Fifth Amendment. Okay, they also violated the 13th Amendment, which is slavery, which is forcing me into servitude because we don't have a contract. Or this is enforcing non-positive law, 42 USC. Okay, everything under Health and Human Services is non-positive, just like 26, the Internal Revenue Code. It's not positive unless you agree and consent to it. And it's all presumptions, okay? So you have to rebut their presumptions, okay? Without a commitment or consent. Clearly, a defendant never had consent, or else they would have produced the contract. The original divorce decree fails. Okay, we've been through that before about service of process. There's no service of process anywhere. They just did it. They just went forward and stamped it and then sent it to the judge. And he stamped it, and everybody's happy because now they got another slave. Okay, so a couple more things. the defendant's defense that's forthcoming, that's going to be, of ORS is only enforcing the order of the court fails because the court never established paternity, has no proof of service, no signatures, no signatures, no signatures, no signatures. Okay, child support is unconstitutional. So this goes, if you just type in child support is unconstitutional, you'll get a couple of different court cases that show that there's issues with an executive branch, okay, which is child support, being able to go in and change the court orders. And they say, well, we need to do it quickly, and we need, no, you can't do that. If you're allowing an executive branch agency to modify judgments, it's void. Okay, it's all void. So you should just type in Google child support is unconstitutional, and you'll get them. There's one from Minnesota. The other one's like Michigan or Montana or something. And so that they've already adjudicated that. They said it's outside their authority. So plaintiff asserted the right to see the contract, form the obligation. The rights of the individual are not derived from government agencies, either municipal, state, or federal. Even from the Constitution, they exist inherently in every man. Okay, unless they're voluntarily surrendered by a citizen to the agencies. Okay, so again, voluntarily is the key word, because when you're getting driver's licenses and the birth certificates, and we've been through all this, okay, this is what they're using. Well, you said that, you wanted a driver's license, so you agreed to all the terms and conditions. No, bullshit, because you don't have all the, you didn't fully disclose all that stuff. So here, I'll let you read that. Okay, then we talk about the Clearfield Doctrine. This is what you're going to try to deal with, or I'm going to deal with, is they're a private corporation. Okay, they're a third-party bill collector. They're not part of the government. They're a third-party bill collector. They're using Federal Reserve notes. Okay, so, and this is the key right here, that like any private corporation, they must be the holder in due course of a contract or other commercial agreement between it and the one upon whom demands for specific performance are made. The government must be willing to enter the contract or commercial agreement into evidence before trying to get the court to enforce its demands, which, again, like, let's go back here. Okay, so there's Clearfield Trust. Okay, so stop, pause, right? Okay, you can read that. Pause. Okay. So anyway, they don't have a contract, that. And if you're enforcing some contract, then God damn it, let me see it. Okay. If not, you're operating under color of law. Immunity also fails because the Supreme Court has held that we, the people, are the sovereigns, not the state or government. Okay. Bond versus United States. ORS is operating in equity. They take money. They're operating in commerce. They're operating in equity, and they're a corporation. Okay. Cut and dry. That's it. Defendant failed in its obligation to produce the contract. The defendant is stopped for failure to respond. Okay. The plaintiff has placed the facts and law before this court. Plaintiff asserts that no lawful contract was offered, considered, and accepted, and asserts that ORS has turned my private property into public property without the required consent. Okay? Party cannot be bound to a contract he has not made or authorized. Bosworth versus Alexander. Okay, so what am I asking for? I'm asking for judicial review of my administrative process. I just want you to look over my documents and say, yes, this is valid, or no, it's not valid, and give me the reasons why. Defendant's forthcoming assertion of failure to state a claim upon which relief can be granted, that's going to be in their motion to dismiss, it always is frivolous and should be denied because relief is stated in this complaint, well documented, with exhibits, and obviously repeatedly pleaded as judicial review and summary judgment. Okay? Plaintiff requests this court to rule on the facts clearly defined in my affidavit and exhibit and execute on the law of the contract. Plaintiff believes that Rule 26 and the tiers are inapplicable. If you look up Rule 26, that is just has to do with the Office of Risk Management. And like, there's tier 1 is 0 to 50, and then tier 2 is 50 to 250, and tier 3 is 500 to, $1 billion or whatever. So it's not applicable. We're talking about the contract for 100 grand. Okay. Now, here's another one that's good. You should pause this and read this. Counsel for defendant is not allowed to add to the record anything. Okay. This is Trinzi versus Pagliaro from 1964. Good stuff right here. The defendant's motion to dismiss for failure to state a claim, unsupported by affidavits or depositions, is incomplete because it requests that the court consider facts outside the record, which have not been presented in the form required by Rules 12b-6 and 56c. Look that up. Statements of counsel in their briefs or argument, while enlightening to the court, are not sufficient for purposes of granting a motion to dismiss. An attorney for the plaintiff, in this case it's the defendant, cannot admit evidence into the court. He's either an attorney or a witness. Okay? So every time that guy across the aisle there opens his frickin' mouth, you ought to be objecting. Statements of counsel are not sufficient for a motion to dismiss. Okay? Excuse me, Your Honor. I need you to rule on my objection so that I can preserve the error. Excuse me, Your Honor. Would you please rule on my objection so that I can preserve your error? Right? Okay. Plaintiff requests summary judgment. Okay? I'm not going to do anything, and I'm going to wait for the time to expire, and then I will not answer arguments or motions because the facts are already before this court. Plaintiff requests and moves the court to have them pay me 100 grand. Okay? For the following reasons. Blah, 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 blah. Violation, conversion. You guys should look up conversion, too. That's what they're doing. They're converting you into a public franchise. Defendant failed in its duty to provide proof of an obligation. Plaintiff moves this court to order ORS to return all funds from 2000 to present, order them to cease collection, and order them to cease and desist, plus any damages. Okay? Release the order of the court to me. Okay? So this, and then of course, always certificate of service, went to the district court, went to the Attorney General's office. Okay? What did I send? This is what I sent. Okay? So we'll see what happens. Keep you informed.